I'd like to invite our closing speaker for the evening, Ambassador R.Bolton. I don't need to introduce him fully again. Lital introduced him. He's a man who needs no introduction, and he's clearly a friend. I introduce to you Ambassador R.Bolton.
Thank you very much. Well, it's a pleasure to be back after such a short time. What I would like to do now is talk broadly about the subject of the law of war and what's happening and how it affects the national security circumstances of both Israel and the United States. And I think to understand this, you have to look at it in a broader context of efforts by people who believe that international law should come to dominate the state system that we have internationally. It's a view that is grounded in international law historically, but which I think lacks democratic legitimacy. A view that international law is superior to national law, and that academics and legal scholars can divine what the law is and tell the rest of us what we're supposed to do. It's really an amazing thing when you think about it. We didn't elect these people. They're self-selected, and they're smarter than us. But it's an important issue, and it's important because in Israel and the United States, when somebody uses the word law, it has sit up and take notice force. We are law-abiding. We want to honor our obligations. But frankly, much of what passes for international law is simply not law. It does not have democratic legitimacy. It does infringe on national sovereignty, and it's a way of binding nations without their consent. And it applies in a huge range of issues, that many of which involve domestic issues, things that we normally consider to be the province of governments that we elect. Environmental questions, for example. There's not a domestic issue out there that doesn't have somebody looking to make it into an element of international law. Issues in the United States, for example, which are very controversial: gun control, abortion, the death penalty. Different Americans have different opinions on those issues, but I believe that that the decision maker on those issues is the citizenry of America. It's not votes in the United Nations. It's not international conventions. It's not international law professors telling us what compelling international norms are. And there's no issue that a nation faces, no decision more central to its existence than when and under what circumstances and how to use force to protect itself. I think a large part of the international law effort to constrain national decisions on the use of force, not simply when we say law of war, what soldiers and service members do in combat, although that's a portion of it, but the larger question of when you use force at all. And I think, frankly, the hidden agenda of many of the people who are involved in this area is to constrain the United States. Then we're the problem. Not rogue states, not dictatorships, not countries that have no representative government, the United States, because it's our use of force that makes everybody else unhappy. You know, under this view in Iran, they would give up the nuclear weapons program once they became convinced the United States bore them no hostile intent. People believe that, including people who sit in the Oval Office. It's a big mistake. But it's important to understand this broader context, because as much pressure as Israel finds itself under, and you well know how much it is, or as much criticism as you get on this specific incident or that specific incident, it's important not to concede the broader intellectual struggle, because if you do, you'll find it impossible to defend your government's actions taken in your own self-defense, as will the United States. And let me just give you a few examples of the theology that surrounds this effort to make international law more comprehensive. I think one excellent example was the NATO air campaign over Kosovo, over Serbia in the late 1990s, when the United States, Britain, and France tried to get a UN Security Council resolution authorizing the use of force, just as we had successfully in 1990 to use force to expel Saddam Hussein from Kuwait. 1990 being the first time the Security Council had authorized the use of force since Korea in 1950, when, by the way, the Security Council authorized countries to come to the defense of South Korea in a UN force. The resolution said expressly, under the command of the United States. Now, that's the kind of Security Council resolution I like. We didn't get that in the Iraq case, but we did get the authorization. The Clinton administration sought Security Council authorization against Serbia in 1999, but faced with a Russian veto, a certain Russian veto, even they decided they would simply act through NATO without broader authorization. This was the reaction of the international community. This is what Kofi Annan, then the Secretary General of the United Nations, said about that decision to go around the Security Council. And remember this whenever you hear a debate about the Bush administration in 2003 deciding to invade and overthrow Saddam Hussein without a new Security Council resolution. This is what Kofi Annan said in 1999. Unless the Security Council is restored to its preeminent position as the sole source of legitimacy on the use of force, we are on a dangerous path to anarchy. The sole source of legitimacy. Really? Really? You have to ask the Security Council? How well would Israel do faced with that prospect? How well would the United States do? Sole source of legitimacy. Speaking specifically of the NATO air campaign against Serbia, Secretary General Annan said that that campaign amounted to a threat to the very core of the international security system. Only the UN Charter provides a universally legal basis for the use of force. Only the UN Charter. And he wasn't alone in this. The then UN High Commissioner for Human Rights, Mary Robinson, the former president of Ireland, said this: civilian casualties are human rights victims. She said, referring to attacks that NATO forces were making on bridges to deny Serbian forces access to the Kosovo area, Mary Robinson said, if it is not possible to ascertain whether civilian buses are on bridges, should those bridges be blown? Mary Robinson, military strategist. But of course, the basic objection wasn't to civilian casualties. The basic objection was to the bombing itself. She said, NATO, listen to this, she said in complete astonishment, NATO remains the sole judge of what is or is not acceptable to bomb. No kidding. No kidding. Now she's a NATO commander. By the way, Ireland, not a member of NATO, just for what it's worth. Then she says, it surely must be right for the Security Council of the United Nations to have a say in whether a prolonged bombing campaign in which the bombers choose their target at will is consistent with the principle of legality under the Charter of the United Nations. Now, this is just flatly wrong. And it's not something that anybody in the United States, I hope, would seriously advocate. Among other reasons, it completely misses Article 51 of the UN Charter, drafted by some very smart American lawyers like John Foster Dulles. in 1945, which permits states to act in their own self-defense. It refers to their inherent right of individual and collective self-defense. And if a right is inherent, then only the holder of that right can determine when to exercise it. That's just good linguistic interpretation. And by the way, that's why they wrote it that way. But now we're in a circumstance where it's not simply the risk of negative resolutions in the Security Council with the creation of the International Criminal Court that I know was discussed earlier today. There's a risk that actions taken by top-level officials in a country like the United States or Israel, if the jurisdictional circumstances of the Rome Statute, which created the International Criminal Court, are met, that these officials could be hauled before the court. Now, let me be very clear what my view on this is. For the United States, when it comes to looking at this so-called international law, I think for the United States, on this earth, there is no authority higher than our Constitution, period, close quote. I don't think there's any nuance here. We're either superior to international law or we're not. And nobody in the United States ever voted to subordinate the Constitution to international law. We're not going to play Mother May I with the rest of the world. We'll decide pursuant to our own constitutional procedures what steps we'll take, and we don't need anybody else's approval. That's one example of how the effort is being made, though, to constrain our sovereign authority, whether to use force at all. Now, corollary to that, obviously, is the effort to constrain what you're allowed to do once you decide to use force. And here, I must say, Israel has fulfilled the metaphor that's often used about being the canary in the mine shaft when it comes to what happens internationally. What happens to Israel first is going to happen to the United States shortly thereafter. And of the criticisms that are made repeatedly of Israel's military response to terrorist attack, the most frequent is the criticism that Israel has used disproportionate force. Now, this was the central conclusion of the Goldstone report created by the Human Rights Council after Operation Cast Lead. It's the same criticism made after Operation Pillar of Defense. I could go on all afternoon with the list of Israeli operations that have been subject to this criticism. It was true in the 2006 Hezbollah war over and over again. So let me be clear when it comes, and this disproportionate force argument is not just one of several. I think it's the most important point of contention. So let me make it clear from a U.S. perspective how I view this. When you're engaged in a military conflict, whether it's against terrorist operations in your own country or more conventional form of warfare, from the U.S. perspective, I do not believe in fighting fairly. I want to win overwhelmingly. I believe in what our military calls full spectrum dominance, which means that the United States is dominant in every area of warfare across the board. Now that sounds kind of belligerent, but the question I ask is, if you disagree with that, what area do you not want the United States to be dominant in? And what country would you prefer be dominant if we're not? Think about that one a little bit. Now, the argument is often made, well, yeah, maybe, but you know, in the case of terrorism, there's a cycle of violence that takes place, and that therefore you don't want to contribute to the cycle of violence. I think that is complete nonsense. The argument that when you are attacked, you respond only proportionately drives you to this conclusion. When Japan attacked Pearl Harbor on December the 7th, 1941, was the proper U.S. response to sink only the same number of aircraft carriers and battleships that Japan sank? Is that proportional? Is that all we're allowed to do? The fact is that legitimate self-defense means not only responding to the imminent attack or to the damage that you have suffered. You are entitled, as a matter of self-defense, to eliminate the threat. Otherwise, you're just going to have it happen over and over again. The way to end the cycle of violence is to eliminate the terrorist threat. It's very straightforward. Now, the questions about authorizing the use of force or authorizing the way in which force is used ties directly into the question of how to deal with allegations of war crimes. And this is where the International Criminal Court, it seems to me, is such a dangerous institution. To me, it's an unambiguously bad idea. It cannot be corrected by technical fixes. It's a product of near religious conviction, but unsupported by any evidence that it's going to have any effect in the real world. Now, part of the argument in favor of the International Criminal Court, or ICC, is that it's an outgrowth of the Nuremberg Tribunal. And so the argument is, or at least the implication is, if you're against genocide, you have to be in favor of the ICC. This is a total distortion of what happened at Nuremberg. And I think it shows why those who favor the ICC really are motivated by something else. The criticism of Nuremberg is that it was victor's justice. Well, exactly, as it should be. And it took place in circumstances that we're not likely to see in anything like the foreseeable future. The Allied forces had obliterated the German government. There was no German government. There was no German economy. The prospect lay ahead for an extended military occupation. And something had to be done with the leaders of the overthrown Nazi regime. We had the defendants in custody. We had witnesses and victims who were now free from intimidation, and we had access to all the records. These political, military, and legal factors typically don't apply in the situations the ICC has jurisdiction over. And so the analogy to Nuremberg fails on multiple levels, but it fails for other reasons as well. The first is particularly when you deal with internal conflict, and you can see this in many places in the Middle East today. There's a real question whether a legal response in the aftermath of hostilities is the right response, or whether the more important objective is reconciliation and moving ahead. We saw, for example, in the case of South Africa, when the apartheid regime was dismantled, that instead of prosecutions of the apartheid state leaders, under Nelson Mandela, South Africa created a Truth and Reconciliation Commission to bring the truth forward if people were to confess, and to try and heal the divisions caused by this heinous system. You can agree or disagree with that in the abstract, but for the people living in South Africa, that was the choice they made, that turning the page, recording the history of the evils of apartheid, and then moving ahead was more important. We've seen in the Central and Eastern European countries with the collapse of communism, they had a very difficult decision to make whether to prosecute the leaders of the communist regimes or whether to try and expose what happened and then move on. My only point is I don't think there's a one-size-fits-all answer here. Sometimes prosecution may be appropriate, but then you have the question of who does the prosecution, and whether it should be an international body or courts of that state. I think political maturation leads you to the conclusion that each state ought to make up its own mind on that subject, rather than impose an outside court. But these are complex questions, and reasonable people can disagree. What you get with the ICC, however, is prosecution uber alles. Everything else goes. Everything is about prosecution, and I think that's a mistake. Now, the most fundamental argument made in favor of the ICC is that evil people will be deterred by the prospect of being prosecuted and convicted. There is not a shred of evidence for that. I'm telling you, the hard men, and typically they are men, the hard men of history couldn't care less about being indicted by the International Criminal Court. These are people who are committing some of the worst crimes against humanity and human rights abuses we can imagine. They're prepared to fight to the death to defend their regimes. In fact, most of them would prefer to die rather than fall into captivity. So the notion that Bashar al-Assad was considering barrel bombing innocent civilians in Syria, but then an advisor came to him but said, "Mr. President, if you do that, you could be indicted by the International Criminal Court." He goes, I knew it. This is the kind of fancy that grips people, that a bunch of judges in black robes and wigs sitting in The Hague will stop these maniacs from carrying out their will, is a way of looking like you're doing something, dealing with crimes against humanity and human rights abuses, when in fact you're doing nothing. Now, the real stakes here to me are that the ICC is a stealth approach to eroding constitutionalism. The ICC purports to be able to deal directly with individuals, not to deal with states, but to bypass the states to go directly to individuals. It is the only international institution ever created to do that. And that is a fundamental erosion of authority, and particularly from erosion of authority from constitutional governments that have representative government. We make decisions about people who violate American or Israeli morals and military standards when they commit atrocities. We know it happens because we're all human. We deal with it because we find it unacceptable. And we don't need anyone else to tell us, frankly, or to second guess us. That's not to say I think similar moral decisions are made in other regimes around the world. Of course they're not. And you know where those decisions are not being made. You live in the neighborhood. But setting up a court that purports to deal with Israel or the United States as an equal to these authoritarian dictatorships is just blinking at reality. And it shows why the hidden agenda is not to deal with Robert Mugabe in Zimbabwe. It's to deal with Washington and Jerusalem. Now, the idea here is, for legitimacy, is that somehow this court is under the authority of what are now some 160 states parties, and that they will provide the check on the prosecutor and the court to make sure that they don't act irresponsibly. Let me just tell you, any institution under the control of 160 governments isn't under anybody's control. And this is where the fundamental illegitimacy of the ICC comes in. In the United States, and I won't speak to Israel's system, but in the United States, authority to prosecute lies in the presidency. The Constitution says that the executive branch shall be led by a president of the United States and such inferior officers as Congress may create. One of those inferior officers is the Attorney General. Supreme Court has defined the Attorney General as the hand of the president in fulfilling the President's responsibility to take care that the laws be faithfully executed. That's our constitutional language. Authority from the Attorney General goes to the U.S. attorneys in all 50 states. So when the U.S. Attorney in the Southern District of New York brings an indictment, he or she is reflecting the authority of the Attorney General, who reflects the authority of the President, who's elected. Nobody elected anybody who put the prosecutor of the ICC in place. Nobody elected representatives who confirmed these judges. There is no democratic legitimacy. It's completely detached. It's a court without a legislature or an executive. And as is a fundamental element of American constitutional theory, if you don't have checks and balances on any branch of government, that branch will behave irresponsibly. And that is the prospect of what's going to happen with the International Criminal Court. And I think, frankly, it has already. It's now largely a European court to prosecute African leaders. This is an indication, by the way, that our gravest fear may not be realized. Our gravest fear being that the court would actually function well. It is now much more likely to go down in history as the sister court of the International Court of Justice, which, since its creation, has done next to nothing positive. So how should we deal, respectively, with the International Criminal Court? For the United States, I proposed 3 principles when the Rome Statute was adopted: no financial support, no collaboration, and no renegotiation of the Rome Statute, because renegotiation isn't going to fix its problems. I tell you, the happiest day of my entire government service was the day I removed the United States signature from the Rome Statute. And my only surprise is that the Obama administration hasn't put it back. They know it will never be ratified by the U.S. Senate. When she was Secretary of State, Hillary Clinton said they looked for a way to sign it again, and I bet she would in the future if she's elected. Fortunately, that's why you have a Senate, to stop this from coming into play. And I emphasize these problems of the International Criminal Court because so much of the rhetoric surrounding it is benign and positive, but it ignores these fundamental defects of legitimacy and its real ulterior purpose. So I would just say, as you look not only at the law of war, but broader developments in international law, think broadly, not just how they affect Israel or the United States in the immediate circumstances where you find them, but think about the big picture. It's not going to go away anytime soon. It does amount to a serious threat, and we need to defend our democratic values, that legitimacy flows from citizens. It doesn't flow from superior institutions. It doesn't flow from wise men and women. Sovereignty flows from us. And if we're not prepared to adopt these ideas, they should not be imposed on us. Thank you very much. Thank you very much.